Just give me a second.
All right, let's try this again. Okay, you should be good to go.
Okay. Okay, can you see my screen all good?
It's saying that you've started screen sharing, but it's just black. Maybe want to go to like the next slide or something. There we go. Now you're up and running.
You see it?
Yep.
Okay,
Good.
perfect. Do you see my notes or just the
I do see your notes. Yep.
let me see if I can just hide that.
There you go. Oh, no, I can still see your notes now.
Sorry, full screen.
Okay, who's the tech savvy one now?
Right? Oh God.
Oh, look at that. It's actually
Oh.
text, right? Oh God.
Okay, so can you see my notes or no?
No, but we somehow it is actually.
Okay, wait, is that better? No,
They were putting on subtitles. It was transcribing your talk.
So weird.
To subtitles.
Okay,
That's
but you don't
cool,
see notes now and we're good.
Now you're good to go.
Okay, perfect. All right. Well, spoke too soon. Shouldn't have given you a shot about being tech savvy. All right. Well, first off, hello, everyone. I still prefer to do these in person, but Zoom will have to suffice. It's so weird just talking to a screen, but nonetheless, my name
We'll be moving to in person soon. We're going to go to in person
soon. I'm looking forward to that. So my name's Sara Castellano. I am a residential and commercial real estate lawyer. So from our last presentation, we kind of went into the process of a purchase, what happens once you submit your paperwork, and what does that look like? So today we're doing the exact same thing, but instead of a purchase, we are going to go through a sale file. So it's kind of same, but different, but I think it's really helpful and will better make you a better agent, knowing my end of the process and knowing what kind of happens once you hand in your paperwork, specifically because you get those questions from your clients without a doubt. And, I think just the better you understand the process will make you a better agent. So let's turn to what we're going to discuss. So again, we're going to discuss the framework of the sale, your roles and responsibilities, how we can communicate and better prepare our clients, specifically what I do to manage client expectations and to manage how they will be able to navigate and how the transaction will unfold. And then some miscellaneous matters that I just want to discuss. So first thing we're going to go through is just a sale. So in a nutshell, this is what happens. Once I receive the offer to purchase, what I do is immediately I reach out to the client, usually within a 24 to 48 hour period. Now, of course, if I receive the paperwork on a Friday evening, I typically will not respond until that Monday morning. Of course, I monitor emails and phone calls over the weekend, but I just kind of do it on an urgent basis. If I get a new file and it's closing in a couple months, obviously, I just wait until the file comes to me and then we open it and then I reach out to clients. So what I do is we open up the file, we complete searches, we do tax search, property searches, some preliminary stuff. We notify the other lawyer that we're acting on behalf of the sellers. We also do things like council tip payments. We contact Manitoba Hydro, all of those things. So that's kind of behind the scenes. What I do is I send out an introduction email. So similarly, like we discussed for a purchase, same thing with a sale is what I do is I send out an introduction email, which you'll see an example of coming up on the next slide. So basically just ask for basic information. It helps I find just tame down clients, worries, basically allows them to understand what's going to be coming next and how the transaction will unfold. So I just find that by this email coming from me directly, and also by reaching out to the clients, it doesn't matter if the sale's not closing for, 60 days or, 6 months, I still reach out to them just so that they're not bugging you going, hey, I haven't heard from the lawyer, or panicking, or, saying what's next, what's going to happen. So that's just something that I kind of try to do so that it alleviates taking that off your plate. So next is, once I receive the responses, I reply with, thanks so much for your replies. I will be in touch closer to possession to book a signing appointment. Of course, if they have any questions or anything like that, I also answer them at that time. Then what happens is, with a sale, we generally can book clients right away. Unlike a purchase, we're not waiting for mortgage instructions or anything like that. So that's fantastic. One thing on a sale is, it kind of depends if it's located here within Winnipeg. Within city limits, it's a lot more easier in the sense of we can simply go online and do a tax search. Now, if it's a property that's located outside of Winnipeg, then we deal with the wonderful RMs. So what that entails is us having to reach out and having to basically mail in a check where we request that they send over the property taxes or the tax search, and then we can go ahead and make our adjustments based off of that. So that is important information that we want to have up front. That's why when clients are located or selling a property outside of city limits, in my introduction email, I actually ask them for their latest tax bill just to see if we can kind of expedite that process. That's something, as you as an agent, I have some agents that are absolutely fantastic, and they will go ahead and immediately, when they know that it's an property outside of the city, generally they already have a copy of the tax bill, and they'll actually send that over to me along with the documents. So just something as an aside, if you don't have it, no big deal. I get it from the agents. I get it from the clients. If I don't have it from the clients, I can always get it from the RM directly, but that does take some time. So we can book signing appointment right away. Generally, if it's, not closing until June, I'll wait until June or a couple of weeks in May to book a signing appointment. But what will happen is, signing appointments are generally about 15-20 minutes, as opposed to a purchase that could be closer to 30 to 45. Again, I always budget about a half an hour just in case client has lots of questions. So we do a signing appointment. I send an email that says, here's the date and time. Here's how you get to my office. This is what I need you to bring in. And then a couple reminders about possession date. Then we meet and we sign, we go over all the documents. We're going to get into what clients bring in at their signing appointment in a moment here. Next, I always make, so in my introduction email, in that subsequent email I send out after we book our signing appointment and at the time of our meeting, we are talking about final reading. So I talk about it with clients 3 times, and I'm sure you as their agent are also having this conversation with them. So I always say it's so important to have a Manitoba hydrometer reading and a water meter reading previous to the last time that you leave the home. Clients get, really excited, and they say, well, I already called in my final, readings 2 weeks ago. And I say, well, City of Winnipeg and Hydro prefer if it's no sooner than 5 days prior to possession. I always try and recommend that they do it as close to possession date as possible. And then what happens is, basically we receive the funds from the other lawyer. So that can, we'll talk about timeline a little bit and what that looks like, because of course you are interested in that part, because once we receive funds, we complete all the payouts, we also send over commissions, which every agent is, of course, we want our commissions, we want our money. So once we receive payouts, what we do is we go ahead and we request payouts. So basically, if there's any liens on title, like for example, a legal aid lien, if there's any mortgages on title, I directly contact the bank and I get those payout statements from them. What a payout statement is basically a snapshot as to how much is owing, and as well as any penalties, any discharge fees, etc. Same thing with any liens or judgments. We directly have to contact that person that is stated as agent on the specific lien on the title or the judgment. We contact them. Sometimes it's that exact registered amount that shows up on title. Sometimes there'll be applicable interest. So we go ahead, we get that payout, and that basically tells us how much to send over. And then once we pay off everything associated with the sales, so normally that's, commissions, mortgage, my statement of accounting, any taxes, disbursements, unpaid taxes, water bill, etc. Then the client goes ahead and will receive their sale proceeds. I'm going to get into how the few different ways that they can receive the sale proceeds. Generally, clients love this thing called direct deposit. So we go ahead and we direct deposit directly into their account. We email them their final report, which shows them an exact statement of accounting, provides them proof of all of their payouts, as well as gives them an account ledger and all final documents. And they get a final report, which is emailed to them. So that's kind of in a nutshell.
Can I ask a question
Of course.
about the, oh shoot, my terminology's off, about all the payout statements. Do you ever, or is it possible to get those ahead of time? So a lot of times I think when you see an agent pulls title, they see kind of a loaded title, they ask some questions, the seller maybe has some answers and not all of them, like they forgot about their legal aid or whatever it is. Is it possible to get those ahead of time so the agent can actually figure out if they're going to get paid or not?
Absolutely. And I think that's so important. In terms of mortgage and stuff like that, I can request payouts, but I do have to request it. Like certain banks expire. So the best thing I can say is it depends, the most lawyer answer ever. But some banks you can request the payout and you can request it as of the possession date. Some banks we request it, but then we'll have to request it again depending when we receive the funds from the other lawyer. Because one thing to bear in mind is we are receiving so the other lawyer who's acting for the purchaser has to request funds from the bank. That bank then has to send funds to their office. Then they take those funds and they send it over to my office. So sometimes it's as little as 1 to 2 days, and sometimes it could take up to 2-3 weeks in some circumstances. It all depends who their lender is. Generally, people are using the large banks and it's not so much an issue. Usually it's quite seamless, which we'll get to in a second. But in terms of if you're pulling title, which we all should be pulling title, say it with me, everyone pull title.
One full title, I will say.
Yes, you have to, because I've seen some people in some sticky situations that they could have easily avoided had they pulled title. Your biggest thing is you want to make sure that there's enough funds on from the sale of the home to cover all of the judgments and liens and stuff that has to be paid out on title. So if you see anything funky on there, call me up, let's talk about it, let's see it. Otherwise, if there is something, let's say like a judgment, CRA judgment, a judgment from a business or legal aid lien, it won't say the exact amount. So I always say, sometimes clients are surprised to see these judgments and liens. They shouldn't be, because Manitoba Land Titles has a duty to notify every single owner on the property when a lien does get registered. So with that being said, if they have a legal aid lien, this one that is common, clients go, what the heck? I didn't know I had this, blah, blah, blah. I would say reach out to legal aid, because I'm not going to request a payout statement until closer to the date of possession. So maybe just get a general idea as to how much is owing. And that way, we know typically it's a nominal amount, but I have seen circumstances where it is a larger amount. You definitely, if you are worried about the amount of funds to close a deal, I would make your sale subject to lawyer's approval, because I have had similar circumstances, especially in the wave of condos and all of that, where clients were barely breaking even. I had clients that owed me money on a sale of a home. So they owed, like, let's say additional $5,000-$10,000. I had one client that had to pay me $20,000 in order to sufficiently close the deal. So in order to have enough funds to pay out the mortgage, to pay out any liens, commissions, etc., because we are the last people to get paid. If anyone's going to be disserviced by shortfall, it's going to be myself and the agent. We are always going to be the last people paid. So it goes in sequence of order as registered on title. So usually go mortgage, whatever is in second position, then third, fourth, fifth. And then if there's any funds left over, then realtors and myself. So we'll get into a little bit more about judgments in a second here. So this is the introduction email that I sent to clients. So it's stating, I need their full legal names, their occupation, I need their name and address of the bank, and I need their mortgage account number. I cannot request their payout statement from their lender without this critical information. So with that being said, they usually say, well, where do I find it? I say on your latest bank statement or on your online banking. Are there any additional charges? Oh, and one thing to note, the reason why I have to ask for full legal names and occupation, it's a law society requirement that I have all occupations, legal names, full contact information, email, phone number, as well as 2 pieces of ID for every single client file. So similarly, how you have to do your FinTrack, I also have to do my due diligence. Are there any additional charges? So this is where they notify me, is there a hydro loan that needs to be paid out? Is there an alarm loan that needs to be paid out from the sale proceeds? Is there any windows on, loan or rental currently at the property? Or are there any secured lines of credit, right? So if there's any loans attached to the property or registered on title, I'll have to pay those out. I also will require the statement of accounting for those. The other thing to note is if there's something called a bridge loan involved, often I'll have to even do things like pay out credit card statements or car loans or items like that. So just something to bear in mind. Then it says, are you currently paying Manitoba Hydro and Reliance Home Comfort for financing? So again, trying to flag and get in front of those hydro loans. Water, so if applicable, if it's a city, condo, or if it's a property outside of Winnipeg. Homestead, do you have a homestead? Do you have a common law partner who has been living with you for 3 years or more? So just kind of circle back to that, homestead rights. If I'm living with my partner, he owns a property, I move into his property. If we've been living together for only a year and a half, I don't have any homestead rights in the property. Once it hits that 3-year mark, I acquire homestead rights in his property. He cannot sell his property without getting my signature and my consent. It's important that we note that because there could be huge legal implications if we are not getting that person to sign off on the homestead right. And so what would happen is both parties, even though my name wasn't on my partner's title, we would still both have to attend the lawyer's office and I would have to consent to the sale. So that's why that's important to note. And then I asked for their full mailing address after the completion of the sale. And then it gives some notes as to that they'll have to bring an ID. You'll just need to bring in 1 key. All other keys and everything can be left on the counter. When you need to call in your final water meter reading, when you may get your sale proceeds, etc. So next over here, this is just stating once I go ahead and I book them into my office to come and sign, this is basically the email that I sent out to them, basically outlining what they need to bring in, how the meeting is going to unfold. I guess one little disclaimer I should have said at the beginning is this is how I run my process. I've tailored my practice in a way through my experiences as to communicate, be a reflection and an extension of agent services. So this is how I run my practice. I can say for certain a lot of law firms do not do this or orchestrate this way. So this is just true to me and how I orchestrate. So just a little disclaimer. Also, I please ask that you don't share any of my slides or take any screenshots. If you want any information, feel free to reach out to me directly. So just a little disclaimer. I just have to make sure that I note that there. This over here is just stating, so here's where our office is located. Please enter through the front doors, report to reception. We're going to need 15 to 20 minutes. Everyone who is required to sign documents needs to attend the meeting. This is what I need you to bring in. So photo ID, a void check. So this is so that I can go ahead and direct deposit the funds. They can either email it to me ahead of time. So void check or direct deposit. Key, I only ask that they bring in 1 key. Otherwise I get like a whole keychain and it's not fun to courier. So what we do is I just ask them to bring in 1 key to the front door, or if it's a code, just let me know the code. And then all the other keys, I go ahead and I ask them to just leave on the counter on the day of possession or the last time that they leave the home. Water reminder. So again, here's the second reminder I provide. Lets them know once you vacate the property, you have to provide a final water meter reading. We are legally required to hold back $1,000 from the sale proceeds. So what I do is I release the sale proceeds, but I hold back $1,000. Then I hold back that $1,000 until either the final water bill has been issued to the seller, and then they go ahead and they forward it to me. I pay it out of the sale proceeds, and then I that $1,000 holdback, and I release the remaining funds. Or they can pay it. They provide me proof of payment, and then I release that $1,000. The reason why lawyers have really cracked down on this, all of us included on our trust letters, etc. This is standard pretty much across the board. The reason being is water is one of the only utilities that goes automatically onto your tax bill if it goes unpaid. Even sometimes with doing all of this due diligence and imposing these trust conditions, we will still run into certain circumstances where all of a sudden the new owner will receive a unpaid water bill or notification from the city of Winnipeg that it has been added to their tax bill. They usually call you in a panic, then they call me in a panic. It's easy to get rectified. We simply just reach out to the previous owners or their lawyers rather and have them rectify the situation. But this is just one way that we try to go about avoiding that. This is just stating some basic COVID stuff, etc. So clients get that before the meeting. We usually find that quite helpful. So when we're at our meeting, this is one of the first documents that I pull out. What this is the statement of adjustments. Now, I've obviously taken out all the other information and client information just for use of our purposes today. But this statement of adjustments is adjusted as of March 7th. So as a seller's lawyer, it's my duty to come up with the statement of adjustments. So whenever you're the seller, their lawyers are orchestrating the statement of adjustments and sends it over to the purchaser. That way, the purchaser's lawyer knows how much their client needs to bring in. So what this is showing is this is how much the sale price was. I purposely chose a condo just so we could kind of touch upon condo fees. This shows that the amount of the deposit, because clients are always going, where did my deposit go? Or how did that money get accounted for? So I find that this is a helpful tool. This is showing realty taxes. So this is showing how much the taxes are. So this is showing how much the total taxes were for the year. Now, the seller's portion of taxes is going to be from January 1st to March 6th because possession date's March 7th. So then the new owners will be responsible from taxes from March 7th going forward. So this over here is showing this is how much their taxes were for 65 days. And from January 1st to March 6th, they actually overpaid a little bit. So the purchaser has to send a credit over to the vendor. So this is showing condo fees. So what happens with condo fees is condo fees are normally paid the first of every month. So since it would have been paid March 1st, the vendor's share of condo fees from March 1st to March 6th is $44. So then what would happen is we will go ahead and we will make sure that my client has paid the $44, and then then the other owner, the new owner will be responsible from March 7th to the end of the month. And it's always up to the purchaser to make contact with the condo corporation and to make sure that they're making arrangements that the condo corp, that they pay monthly condo fees directly with the condo corp. This is not something that lawyers can do on clients' behalf. So this is something critical that whenever I'm working with a purchaser, I actually make them initial something stating that they agree that they will contact the condo management company. So that's how that works. Basically, if it's in the middle of the month, we just adjust accordingly. And basically, essentially here, one thing to note is, let's say if my clients already paid for condo fees, they would be reimbursed for, the amount that they overpaid. So since they've already paid $229 for the full month, they'll receive a reimbursement for that overpayment, but they minus the amount that is their portion. Next is sale proceeds. So it's really important that we manage client expectations. Do not overpromise. Do not say you're going to get your sale proceeds in 1 to 2 days. I think it's better to underpromise than overpromise. I'd rather clients be pleasantly surprised than upset. Sometimes especially if you're not pulling title, you don't know what's kind of unraveling behind that title that's registered. Obviously, if there's more judgments, if there's more liens, it's going to take more time. If there's only one mortgage to pay out and it's a major bank like RBC, for example, those are generally easier to deal with. However, if let's say it's a private lender or if there's multiple payouts, that will take more time. So again, I always say anywhere to 1 to 4 weeks, even when I'm on the phone. Generally, it's a lot quicker than that, especially being an all real estate law firm. A lot of the time I can get clients paid out in as little as a week or under that, even some few days. It kind of depends if we're closing by NCP, which we'll get to in a second here, but just something to definitely acknowledge. I know we want it to move along as quickly as possible, but there's certain delays that I can't account for. For example, let's say previous owner, let's say the new purchaser is dealing with a lender and they're being slow to fund the mortgage, because we don't always fund the mortgage right on the day of possession. It also depends who the other lawyer is. So those two things are out of my control, who their bank is and who their lawyer is, because that could determine how quickly they send over the sale proceeds. So for example, just because the deal closed on March 1st, I could technically not be getting funds from the other lawyer until March 7th. Every day that they are late, the seller gets interest until they are paid out in full. So they do accumulate daily interest. And I do note that when we are at our meeting. However, once I receive the funds, then we have to request certain payouts. Sometimes we do try to do that ahead of time. But again, if those have expired during that time frame, we have to re-request them. Then sometimes we're waiting on payout statements. For example, right now on a file, I'm dealing with a legal aid lien, and it's taken them 3 weeks to get me a payout statement. And it's not for lack of trying. So it all depends. Again, there are certain things that we do in place. Sometimes I'll just hold back the amount that the client has advised me the legal aid lien is for, and release as much sale deposit as much sale proceeds as I can. One thing to note, even if NCP is written in the offer, if the banks don't agree and if the other lawyer doesn't agree, some law firms refuse. The reason being is, it depends. Some lawyers are old school, or if they're non-real estate lawyers, sometimes they just don't even operate with using NCP. So NCP basically allows us to use title insurance and to exchange funds faster. So I always close NCP on majority of my deals unless the other lawyer refutes that. So for example, I had one deal that closed this week. Other lawyer said, no, I'm not using NCP. If they're not using protocol, I legally cannot release sale proceeds until the registration has occurred on Manitoba Land Title's office. So in this circumstance, it took 1 week, which was really quick. But let's say, in the height of summer when things are really backed up, it could take up to 2 to 3 weeks sometimes. And that's if there's no mistakes or any, edits that need to occur at Manitoba Land Title's office. Sometimes there's correction letters that need to go back and forth, because let's say if their lawyer registered their client's name wrong, or there's just so many things that are out of my control. So even if we close NCP, if we close by NCP, then I'm able to exchange the funds and get the clients the funds a lot faster. But again, it's not always guaranteed. So next is when to get.
Can I interrupt you on that one, Sarah, for a second?
Mm-hmm.
So a couple notes. One of them is also, so if you notice that how many things are out of her control and delayed in getting payments, that also affects your commission. So if commissions are taking a while, again, you get paid when we get paid, and we don't get paid until Sarah gets paid, and or the lawyer, which can again take weeks, and sometimes even longer to do, depending on certain factors that are beyond our control. And I know when Sarah was working for us, she was doing some commission calling, right, and hounding lawyers for things.
Mm-hmm.
Things like, so it can take time. That's so your commission is completely tied to all of this as well. And the second thing, I was just curious, Sarah, on NCP, you said you closed the majority of yours. Do the buyers and sellers have to consent to it, or can you just automatically assume that they want to close NCP, or do you actually have to get their permission? Like if the offer doesn't mention anything about NCP, do you have to get permission before you can do that? Or
yeah, that's a great question. So what we do is we automatically reach out to the other lawyer. And when I'm reaching out to the other lawyer, I'm saying, are you in a position to close this by NCP? Hey, I'm acting for the sellers. Are we closing this by NCP or not? So we know right up front. The other thing is, if the purchaser's clients refuse title insurance, we can't close NCP, because you need title insurance in order to close by NCP. So I have had clients, purchasers who have stated, you know what, we're not going to get title insurance. Their lender made them sign something or just get title insurance just for the lender. Some lenders require that you get it and they have no choice, but there are certain circumstances where if they sign certain disclosures or whatever, they can opt out of title insurance. And if they're not closing by way of title insurance, we are not closing by NCP. And again, that'll delay the funds. So there's so many different factors. I mean, these are worst case scenarios that Mike and I are talking about. At the end of the day, generally things are seamless, and I would say 80% of deals close, in 1 to 2 weeks time, and clients are super happy and thrilled and think that, that's great, I got my money so quickly. But there are circumstances that do warrant a little bit of a delay, and definitely something to keep in mind. I know there are some lawyers that refuse to release sale proceeds until all the matters have been completed and paid out. I release sale proceeds the minute that I have funds and I'm in a position to pay. So even, for example, on this one property that I'm waiting to pay out the legal aid lien, I've already paid out real estate commissions, but I've done so because I already know how much is on the legal aid lien, because I had the client inquire, and the agent and I also talked about it previous to receiving that payout statement. So I was comfortable. I was in a position to go ahead and pay that out. There are some lawyers that will not until absolutely everything, or even sometimes the water has been paid out.
So reason number 139 to you, Sarah, again, because you get paid.
Get paid as quick as you can. Yeah, exactly. I make sure that because I was one of the people that was calling and hounding other lawyers for commissions, I pride myself on the fact that I do not get those phone calls about hounding commission. So next, what we do is when you should get a bridge loan, I always say clients should have a bridge loan lined up, even if their possession date is 3 weeks within one another. I always say better safe than sorry, because these circumstances can happen. Also, what happens if the purchaser has a delay and all of a sudden we have to move possession? So I always say better safe than sorry. If the possession dates are within 3 weeks of one another, always make sure that they have a backup of a bridge loan. Otherwise, push it out. So just something to note there. So definitely do not have the sale and the purchase happening on the same day, or even if I would have them at least, a few days within one another, because bridge loans can be tricky and it depends what bank they're using, etc. So definitely these are conversations that they should be having with you, with your lender, and with their lender specifically. We request the mortgage payout statement. So again, we contact their lender, request out the payouts. What we do is we notify them that they have to pay off their hydro bill, but in terms of their hydro loan. So recently, Reliance and Manitoba Hydro has made it that the lawyer's office cannot directly request the final statement. The seller actually has to request it directly from them, and then they go ahead and they issue that bill to us and we pay that off. Or they can pay it directly and then show us proof of payment. But if they want to pay it off directly, it has to be paid off prior to possession date. If it is after possession date, the other lawyer is going to enforce trust conditions on me, and I'm going to be legally required to pay that off out of the sale proceeds. Now, if there's any transferring of any hydro loans or rentals or anything like that, you want to get in front of that and you want to make sure that that is occurring prior to possession. Also, make sure that you do inquire into how much is actually left on the loans. Sometimes clients got looped in and swooped in, especially these poor older individuals that I sometimes see in these rental contracts that they get swindled into, and they're really surprised at the amount that they owe. So again, something to factor in, especially if, let's say, you're going to write it on the listing, or if the purchasers want to take over it. We're required to pay off the water bill, or the seller can provide us with final proof of the water bill. So again, sometimes that can take a couple weeks. The city of Winnipeg is notoriously slow for issuing the final bills. So whenever that's received, then we go ahead and we release that $1,000. Then we go ahead, of course, we pay off commission as well, any other loans or credit cards if requested by the client or by the bank. One thing to note, every lawyer office operates the same way. So we're only operating thinking that we're only paying off that mortgage. If there's hydro loans, if there are credit cards, any additional registrations on title that we have to pay out, there will be additional discharge fees and there will be additional fees for clients. So just something to note. Then what we do is we direct deposit the funds directly into the client's account. They can pick it up, check if they wish, or we can mail it to them. But generally, clients love direct deposit. They get their money instantaneously, and I send them their final report by email. So just a few miscellaneous items that I want to discuss is judgment. So sometimes clients will see something registered on title. So something like an RBC mortgage. If we see an RBC mortgage on there and they go, well, they start to get, all up in arms about it. Well, what the heck? I paid out my RBC mortgage like 3 years ago. Sometimes the banks do not properly discharge them from title. So if they don't do so, sometimes I have to go back to the client and say, hey, do you have proof of payment of, this RBC mortgage that you paid out 3 years ago? Can you send it to me? And then we can get it to fall off. Or sometimes some banks will I'll contact them, say, hey, client advised that they paid it off. They'll say yes, and they'll remove it. Judgments. We need discharge forms. So what happens, let's say, if a business registered a judgment on title, it'll say who the contact agent is. So if it's another law firm, I reach out to that lawyer, I request a payout statement from them. They will go ahead, provide me with the payout statement. Once I send over the sale proceeds or the funds, so let's say it was a judgment for $5,000. Once I send over the $5,000 plus any interest that accrued, then they go ahead and they will provide me a discharge form. So I can go ahead and remove that. If something was paid out on title, if something is registered on title, but it has been paid out, the client needs to provide me proof of that discharge form. So sometimes, again, businesses will just not release their interest on the property, even though they've been paid, but clients should have received that discharge form. Or we need to order one if the client does not have one. So right now, an example of judgment, I have a current file that is super messy. Title was not properly pulled before closing on the deal. We've had to push possession 3 times now, and it likely will continue to be pushed for a couple months. There's judgments between different jurisdictions. There's a judgment of a business that is no longer active. So there's no person for me to contact. It actually has to go through the courts and has to get an order to be discharged with, which is going to cost the seller a lot of money. There was judgments for a unpaid child support. Clients' children are now in their 30s, and this was in different jurisdiction as well. So we're dealing with that. It has to go all the way through family court system to be removed. So all of this is going to take some time to be dispensed with. There's also CRA judgments. CRA, we have to go ahead. We cannot contact CRA on the client's behalf. A lot of clients just say, oh, just go deal with it. It's a matter of the clients have to get a payout statement. So there's a lot more complexities. So just something to be, aware of and account for. You're not going to be able to close a deal in 1 week's time if there's a significant amount of judgments, or if there is, we can get in front of them, right? If it's starting to be listed, or if you know that it's going to be listed, we can start to work on these things ahead of time to get in front of it.
Again, another big shout out to pulling title.
Yes, pull title, please pull title. Next is the will and probate. So I get a lot of questions about this. So when someone passes, so if husband and wife are on title, if the husband passes, immediately all the property, if not spoken to, it goes to the wife that is on title if they're registered as joint owners. However, if let's say then the wife then passes away, what would happen is her will would speak to who does the property go to, etc. So hopefully these people were smart individuals and they got something called a will. And then what would happen is a will has to be probated. So if your client calls you and says, oh, my mom just died, 3 months ago, my dad also passed, before her, your first questions should go, did they have a will and did it get probated? You technically cannot sell the property until the will has been properly probated. I know sometimes we do sell the property, but then we just make it subject to probate. which is definitely something that you want to write on there. And you also want to make sure that your purchasers are flexible. There are some different things and some different circumstances and arrangements that I've made. There was one circumstance where the will had to get probated. They were still working on it with their estate lawyer. So what had happened was clients just moved in and they rented from the estate until the probate was going to go through, and we could go ahead and properly orchestrate the remainder of the deal. If let's say a circumstance was husband and wife and husband passed away, I would need the husband's death certificate. People get death certificates confused. We need the one from Vital Stats, not the death certificate or the proof of death from the funeral home. Okay, so something to note. And again, if you are listing a property and somebody has deceased whose name is on title, we will need that. And that is something that you want to get your client to order from Vital Stats as soon as possible. Sometimes they're behind. You can rush it if need be. You just pay an applicable rush fee. But sometimes I've seen Vital Stats be, 6 months behind. So just make sure that you are on top of that. And again, so probate, we need the probate to go through, and then the executor can properly sign off. Power of attorney and probate, or a power of attorney and a will, are two separate things. If someone has power of attorney, they cannot sell the property once the person has passed away. Power of attorney is only used if, let's say, they are mentally incapable and they have the capacity spoken to and the power of attorney. If let's say, their health concerns doesn't allow them to, attend the property. So this was used a lot in COVID times, when, especially with older individuals. There has to be a specific clause that allows them to dispense with the property. If that clause is not in the POA, you cannot sell the property and the deal will completely fall through. So I have seen this happen. So if you're ever concerned, ever not sure, make sure that you are reading through that POA and that there is a specific clause stating that you can dispense with their power and sell the property. Power of attorney, we need the original or notarized copy. So the client needs to bring that in, same with the probated will, at the time of our signing appointment. So we all require original documents. I go ahead, I have to notarize it and state that I've seen it. If there is no POA and the person is incapable of assigning, sometimes I'll get phone calls, hey, my father's got dementia. I want to get POA. Well, unfortunately, they can assign POA because they no longer have the mental capacity to assign you that power. So the way that we get around that is by assigning committeeship. This is a complicated process that you would have to go through the wills, you would have to go through the courts for. And committeeship is basically assigning you that power as their family member if they see fit, and if they see that you are, once there is a doctor attesting to that family member's dementia, etc. So this too requires additional steps, but it is something that can be dealt with.
If you don't know what that is, you can watch the Britney Spears documentary.
So taxes, just one thing to note is when clients sell their property, just make sure that clients are continuing to make payments on their mortgage and their taxes and their water and everything else. Sometimes people get really excited and they just decide to seize all payments. We definitely want to make sure that they are continuing to make those payments. When clients meet with me, so even if the deal is closing March 1st and we met April 1st, technically, I will not be in a position to close the deal until the exact date and time of possession. So sometimes clients are of the belief, well, I met with the lawyer, the mortgage payment should stop. That's not the case. They have to continue making all payments. This is something that we discussed at the meeting and is stated in my documents and emails, but it is something that you should also be having a conversation with your clients, especially if they're simultaneously purchasing and selling. Tips, our office goes ahead and will cancel tips and will pay any outstanding property taxes. So if your client's in tax arrears for the last 5 years and there's $11,000 worth of taxes, which you would be surprised, all of a sudden we have to pay that out of the sale proceeds. And that is it and all. So thanks for tuning in. Thanks for having me. Hope that provided a little bit of insight. And yeah, if anyone has any questions, feel free to reach out to me. This is my contact info.
Absolutely. So again, thank you, Sarah, very much. I'll give it a second if anybody has any questions, but again, I will give Sarah one more fantastic plug. As you can tell, she's an amazing lawyer, takes great care of your clients, also very realtor friendly. So again, just again, number one reason number 139 on why to use Sarah. So give her a shout, send business, send leads, right? Send clients to Sarah. Okay. I don't see any other questions coming in. I think, are you going to stick around for the last little bit here? Or?
Yeah, sure. Yeah.
All right, because we got some what would you do? So I asked Sarah, I said, hey, maybe stick around and watch and see if maybe she can chime in and point out all of my mistakes. Oops. All right, where are we going here? Okay. So I got a few what would you do's situations. It's been market's been picking up, it seems like, because my phone rings a lot, which is great. Here's one. I don't think, make sure I didn't screw this up with any phone numbers. No, I didn't. So here's a text message conversation that was sent to me last week, right? The gray box is the listing agent, and the green box here is a buyer's agent. Yeah. So anyways, the listing agent says, I'm going to weigh my percent. They say, thanks. Can you call me please at 133, 134. They say offer accept. I'm assuming that says accepted of 285, 583. And then half an hour later, they ask, hey, can I scratch off no galvanized? Right. And then essentially there's some phone conversations that are going on here. Right. And then yada, yada, they're kind of arguing back and forth saying, hey, I thought I had a deal. And this agent then texts back at, 40 minutes later and says, well, if your clients aren't going, we have another offer open until 3 o'clock. I need to know what's going on. We accepted the price, but we did not accept all the other conditions. My broker said it's a counter. Right. Hence why I get a phone call and I'm starting arguing over the phone with other brokers and other agents. So the question here is, it looks like we have an accepted offer, right? This was my case or my point saying, well, hey, it says offer accepted of that price, right? And then half an hour later, they try to, whoops, I missed something, because in this particular offer, the offer said, that the seller promises there's no galvanized plumbing in the house. And they said, I guess they went and thought about it after they accepted the offer and said, we don't really like that. Can we make a change? And the agent, essentially the buyer's agent, said, why? You've already accepted the offer. And here comes the backpedal of, well, no, we didn't accept all of the other things on there. We just accepted the price, right? Which I essentially called BS and said, no, that's not that's not what's going to happen. You accepted the offer, tough luck, whatever's on the offer stands. The agents eventually did call and talk and blah, blah, and it all got worked out. Anyways, and again, Sarah, for chime in whatever I'm wrong, but what I put in here is right from the Wonderful Law Society of Manitoba, right? In the real estate section on their educational course, it says here that yes, the Real Estate Act, which is now called the Services Act, of course, does state you need to have offers in writing. However, the act does not state that failure to do so invalidates an otherwise valid agreement. So the normal common law relating to verbal agreements likely still applies. Therefore, verbal acceptance or verbal offer may be binding on the vendor and purchaser if it can be proven, right? Notwithstanding, the broker will be in violation of the act for presenting accepting offers verbally, okay? So what this essentially means is common law, contract law states verbal agreements are allowed. Verbal agreements actually have force and effect, right? And certain jurisdictions do not allow for it for buying and selling of real estate. I believe that our neighboring province does not allow this, but in Manitoba, you can actually sell land, sell property verbally. Where the case or where things usually rise and fall is on the proof that there was a verbal agreement. So hence a text message, and that is what the text message itself doesn't have a lot of power. It's the verbal agreement. The text message confirms, yes, this is what we agreed to, it was communicated back, and there's an actual deal. Right. And I've confirmed this with a couple of lawyers. Caveats have been placed on properties for this type of thing. I don't have the case law. I don't know if Sarah has it handy, probably not, because there is case law apparently that exists for verbal agreements and contract and sale for real estate. So anyways, what to say is what would you do is, of course, contact, your brokers and all that kind of stuff. But you need to know, again, I said, but the emphasis here is, most of these problems with multiple offers and these things all happen over text message and these verbal back and forths. No, just when you say something like this, again, whatever side you're on, you say something like that and you're against somebody who knows the law, you're going to say, nope, that offer's accepted. And yes, I would say the lawyery answer, again, Sarah, feel free to chime in if I'm wrong, is yeah, they could probably fight, and say, well, no, we didn't have complete meeting of the minds. We didn't know exactly what we were accepting, etc. However, this is enough here to say for the buyer, if they want to place a caveat on the home and say, you're not going to sell this other offer, it's ours, it's a pretty good chance.
Just to chime in there, Mike,
Yeah, please.
I think the only thing too is, it's so important to know the difference between discussion and negotiation and actually making an offer. And something, because lawyers are so paranoid about this, you'll often see that whenever we send emails or offers to one another, even in writing, we will say without prejudice. Now, I'm not saying you need to put that on your text messages or something like that, but make sure that you are making that clear distinction. If you did need to, he should have said, or had a conversation about that they still needed to negotiate the other terms before agreeing to that. So again, just making sure that you understand the difference between when you are making a discussion negotiation and actually making an offer or an acceptance or something like that, just for the reasons exactly what Michael just stated. So just be wary and cautious of that, and make sure that the other party is on the same page as you. And hey, I just want to have a discussion about this before we come to an agreement, and making sure that you are clear about your intentions.
Absolutely, right. And we're going to talk about that in the next one. There is a question that came in. It says, is it really considered verbal if it's in a text? Wouldn't that be considered written communication? So I would say, again, yes and no, sort of a thing. The fact, for number one, the Brokers Act or the Services Act does not say that text is writing. They specify writing being like inked, typed, or whatever it is through, DocuSign or something like that. They don't consider text to be writing, but I think it would fall into the case of acceptance was communicated, right? Because I believe contract law talks about communication, and that's where communication would be received via text. So it would be text be seen as communication. I don't know if it would be seen as in writing as per the Services Act. If I'm wrong, please help me out, Sarah.
Anyways, I concur.
Why didn't I concur? Okay, so that's great. The next one, sort of on the same vein here, and again, this is really going to go to Sarah's point about clarity, right? Sorry, actually, it's a different one that's about clarity. Or is it this one? This one is about clarity. Sorry. Offer written at $350,000. Obviously, the arbitrary numbers made up. Listing agent calls back to say their offer is in the top three and that they're considering, which is allowed to do. You can say, hey, there's 10 offers. We're looking at 3 of them. I'm allowed to say that, right? Buyer's agent texts back and says, please increase offer by $10,000. Right? And it says, okay. Listing agent texts back and says, offer accepted at $360,000. Okay, so clear acceptance. They can kind of confirm the price. However, buyer's agent calls the buyers with the good news. The buyers say, well, I didn't offer 360. We said 355. And a silence fell over the crowd, right? Uh-oh, what happened here? So I will say, I will give the agents great credit that they actually worked this out, and they did a fine job remedying this. But nonetheless, this is what happened. Essentially, there was a mistake made by the buyer's agent. They thought or remembered that they wrote 345 instead of 350. So when they increased by 10, they thought they were increasing to 355 instead of 360. So by the $10,000 there, they again misremembered what their offer was. And again, so it was an oopsie, right? But nonetheless, what happened here is, well, the sellers accepted it, right? They said it's 360. The agent, as an agent for the client, your agent you have proxy, and you can speak on behalf of, that's what's representation to this offer. And it was accepted at $360,000. That's a binding contract. Again, based on back to our verbal acceptances, or acceptances being communicated, they clearly accepted the offer of 360. The counter was right there, or the increase was right there. This offer is done at 360, right? But the buyers say, what the heck? You wrote me into a contract I didn't want to go into. And this is where I think there's probably, Sarah and I were talking before this about, how valid would this offer actually be? In this case, what they essentially did was the buyer's agent admitted the mistake, which is very commendable. And they lowered the price to 355, what they were intending on doing. And the agent is coughing up the $5,000 to compensate the seller because it was their mistake. So a very noble buyer's agent, but it's a $5,000 mistake, right? So clarity, of course, is very important. But again, and these types of acceptances, again, very important to know when you're accepting and when you're just discussing. But anyways, on the question of, well, how valid would it be? It would depend. I would think, Sarah, was the answer we said was how adamant each of the side's lawyers would be, because one side said, hey, it's clear as day, you've accepted the offer. The other side would say, well, my agent acted, didn't say the right thing to me. I told them one thing and they did another thing. Nonetheless, I think it would be a bit of a battle and a bit of a war. I don't know who would win, Sarah. Was that kind of
Absolutely. And
Yeah.
I hate to, most lawyer answer, it depends. It's so circumstantial. Of course, you never want to end up in a circumstance like this, but if you do, it completely depends. I think first and foremost, lead with kindness. I'm just going to remind everyone of that, especially when it's stressful and everything's heated. You have a million things on the go. I get it, especially while we're heading into busy season. I think that's a good reminder. Lead with kindness before we get aggressive and all of that. And that's why I always recommend that, even closing issues, all of that. Have a conversation with the other agent amicably before we get lawyers involved and brokers involved and, we're throwing things up in the air and whatever. I think having a conversation goes a long way. This definitely could be argued that, it is valid and it is, binding. And I think that is absolutely amazing and speaks to that agent's customer service that he was willing to cough up that additional 5,000. But with that being said, I have seen circumstances where if errors or stuff like this occur, and this is why reputation is everything and how you treat people, because some agents, if there are a mistake or something like that, hey, you know what, you're a good guy. We've worked on a couple deals together. I understand mistakes happen. I'll go back to my sellers, explain what happened. And sometimes they understand and, they'll agree to make those amendments. I dealt with an issue where last month where a client was mistakenly pre-approved for 350 and 450 and had a pre-approval letter, everything. I made an offer on a property for 288, thought that, they were well below their realm, all of that. Turns out that the bank mistakenly pre-approved them and they were actually only pre-approved for 250. Well, she already made that offer and already provided them with a $15,000 deposit. It was a legally binding contract, but the sellers were kind enough to understand the circumstance, release the deposit, and go on to the next offer. So it all depends.
Yeah, absolutely. Okay, similar one. This was a doozy. Anyway, I won't tell all of the fun details of it. But anyways, two offers. One was written at 275. Again, making up numbers here. Conditions are left blank. No deposit provided. Right. So the listing agent gets this thing, and they say, "Hey, like you just left your conditions blank. Are they included? Are they excluded? What are you doing? What's about with the deposit? Is it within 24 hours? Like it didn't say anything on the offer. It was just kind of a poorly written offer, right? So the buyer agent clarifies, nope, there's no conditions, and I'll give you the deposit tomorrow. Says, okay, great. Listing agent says, okay, everything looks good. I'll send to my seller. 20 minutes later, listing agent texts and says, the buyer's agent says, thanks for your offer, but we sold it to the other offer. Right? Everything seems normal here, except that the buyer's agent said, but I already told my buyers it was accepted. They said, you said it looks good. I told my buyers it was accepted. Buyers actually went to the house. Anyways, the buyers raised all hell because their agent told them that it was accepted. Meanwhile, the listing agent's like, what are you talking about? I said, it looks good because you wrote such a crappy offer. I had to clarify what the heck your offer actually was because you didn't know how to do your job. And anyways, war ensues, buyers get involved, buyers go nuts. Also, other, buyer's agent, throws listing agent under the bus and calls them all kinds of bad words and names and whatever else it is. So completely mishandled. Anyways, again, a fun little horror story. And what we do anyways is, again, this goes back to Sarah's point about clarity. Looks good is not acceptance, right? Nowhere near is this acceptance. And this is where on the listing side, we're like, what's this buyer's agent? They're crazy. Like you have no idea what you're doing. But nonetheless, right? Clarity, especially when you're negotiating this back and forth, verbally, over text, all this kind of stuff. Again, I'd say 4 to 5 problems that hit my desk are from text messages, from dealing with multiple offers and phone conversations and text messages, not being clear, not knowing what's a counter, what's not a counter, etc.
And just one thing to note is even when a verbal and whatever, like, it has to meeting of the minds, all the other requisites and formation of a agreement need to be met. So in that circumstance, that word, what he stipulated was not legally accepting the offer.
Yeah. Beauty. So here's one you probably, if you haven't encountered this yet, you probably will, because it's spring and basements are flooding. Your listing is bumping, you've already counted your money, everything's going fantastic, right? And then at the open house, there's actually some realtors there, say, hey, there's water in the basement, things are wet down there, I got a wet sock, etc. Right? And you've already supplied and distributed a PDS, and there's actually one at the open house, I should say, and the PDS is clean, right? Clean PDS. It's out there, you've given it to everyone, right? Offers are coming tomorrow, you already got 2, and there's others saying you're writing. What do you actually do? What do you have to do, right? So first, a couple different rules. Number 1, water in the basement is not considered a material latent defect where you are obligated to disclose to somebody if there's been water in the basement. The PDS does ask it, but you're not obligated to provide that information. If you had no PDS, you walk through the house, as another agent as well. If it was your own client, of course, you do owe that disclosure, right, in limited joint. But in outside limited joint, you would not have to offer water in the basement. You could offer if you want to be kind like Sarah, but anyways, you do not have to, not obligated to disclose that, right? A seller isn't, and neither are you. However, in this example, you have, and this is where we said, well, they've already supplied and distributed PDS and advertised one. That's clean, right? So basically, they've represented the house as there's no water in the basement. They've kind of put it out there for everyone, and now there is water in the basement. There's a change. So this is where, with the New Services Act, there's a heavier onus on agents for misrepresentation and misleading the public, right? It's way heavier hammer. So what we advise the agent in this case is like, well, now if there was no PDS distributed yet or anything like that, you wouldn't really have to do anything, technically speaking. But because you've advertised, there's offers in with attached PDSs, you've made these representations, you've advertised a clean PDS, and now it's factually incorrect, your advertising could be seen as misleading. And I would probably say it is misleading, right? Because hey, everything's fine. And then, oops, it's not fine, but I'm not going to say anything, right? I would call that, not great realtoring. Nonetheless, it is up to you. You have to have that conversation with the seller. They have to notify them. Unfortunately, the seller lives, they weren't in the home because they were gone all week for a hotel or whatever they did. So they had to be notified and say, sorry, like your basement's leaking with all the spring melt, should have shoveled. And now the advertising is out there. It's misleading advertising. We don't want to get anybody in trouble. So like I said, they led with kindness. They notified all the people that here's what happened. They tried to find as much information about the water as possible, where it was coming in, how much was it, all this kind of stuff, maybe potential remedies. And then they disclosed that to anybody incoming, and everything did work out in the end and sold. Everybody was happy. Okay, so just letting you guys know a couple of things about water in basements. Again, this may be happening to you with the spring melt, so make sure you know all the stuff about water. Any questions or comments on that, or am I wrong on anything, Sarah?
No, you're pretty on par with everything there. Yeah, you get an A++.
Look at that, fantastic. This meeting is subject to lawyer's approval.
Make sure, and with lawyer's approval, please make sure you're giving sufficient amount of time on that note.
All right. Well, hey, while we're on, what's sufficient amount of time? How much time do you need? 20 minutes, half an hour?
What I always say is make sure that you have the financing condition occur prior to the lawyer's approval, because there's no point. Sorry, I'll turn on my video. There's no point in having lawyer's approval if financing is not going to go through. So I don't think it's I think often it's practice to have them both occur on the same day. And I think financing should occur, and then a couple days later, it should be the lawyer's approval. Because sometimes I'll complete the lawyer's approval, but then financing won't come through. And then, it's kind of a waste of everyone's time, so to speak. So I think at least a week, but especially in the busier months, I would say almost 2 weeks You know, one day is super unreasonable, 2 days is unreasonable, 3 days is okay. But again, that you have to make sure that your lawyer has time for it and that they can make that a priority. Some of my agents are great at calling me and saying, you know, hey, I know it's quick, or hey, what time do you need, etc. Ideally 2 weeks. But if you have to go a little bit less, like a 1 week, that's fine. But just make sure that we get it in time too, because sometimes by the time we get it, it's due the next day, and then we have to ask for an extension.
Yeah. I would imagine also the complexity of the deal will, you know, depending on what they're approving, right? If you get standard residential offer with nothing
Then
on it. Yeah, but
absolutely.
commercial properties and things like that, and
Absolutely.
complex deals and whatever else, I'd
And
imagine.
and just so like, just to understand the other aspect of it, you know, it's not so much as me just reading through a contract. My process is very different. I reach out to the clients, let them know, I review the paperwork, then I have a meeting with them. You know, do you have any concerns, anything you want to go over? Then I'm corresponding with the other lawyer. But also, all while that's happening, it's impossible to do proper due diligence in one day, because I have to order searches. Like, I won't even have the searches and all of that and all the information to make a proper due diligence in such a short time frame.
Yeah, absolutely. Cool. Well, again, thank you, Sarah, for chiming in on everything. We're over time, and I know there's some more left to do. So I apologize if I'm breaking any hearts here with not getting to the 1-minute market update videos, but I will do it again, I promise. And if you're really, really insistent or need that today or something like that, let me know, and I can happily walk you through it. It is pretty quick and simple, but we're well over time. So anyways, thank you, Sarah, again for tuning in.
Thanks for
joining
having
us,
me.
right? And educating us and giving us our stamps of approval.
And then
Okay.
next time,
Last thing I'm going to say before I go, reminder of the April 6th marketing training meeting, April 30th as well. Also, I just forgot. Oh, for anybody who's watching with this whole PREC stuff, I spoke to, so it was on Wednesday last week, Securities Commission said it's going to happen either Friday or Monday. Friday and Monday have passed. It's not done yet. I emailed them this morning. They said, we're almost there. We're so close. That's what I got for you. Shocking that Securities Commission doesn't have their act together. Shocking. But anyways, we're waiting. And as soon as everyone knows, you're getting an email from MailChimp, I believe, from the Securities Commission. Anybody who's watching, we're waiting for that. So stay tuned. You're going to get the email right when I get the email. So anyways.
Thanks for having me.
Thanks, Sarah.
Bye,
Okay.
everyone.
Ciao, gang.